Hello, and thank you for joining us for today's webinar, Practical Impacts of the Age of Criminal Responsibility, Perspectives in Public Safety Professionals. My name is Allison Friedman, and I am with OJJDP's National Training and Technical Assistance Center. As your technical host, I would like to take a moment to discuss a few features of the Adobe Connect webinar platform and provide a few announcements to keep in mind. For those wishing to download a copy of the PowerPoint slides and webinar-related handouts, you may do so by locating the Handouts pod directly above the chat area. Click on the name of the file and then click the Download button. At the end of today's webinar, there will be a Q&A session where the presenters will address some of the questions posed during the presentation. Please type your questions into the chat box as they arise. For those of you participating in today's webinar as a group, please take a minute and help us count. Go to the chat window and type in the total number of additional people in the room with you today. If you are viewing alone, there is no need to type anything into the chat pod at this time. Following today's webinar, attendees will be sent a certificate of attendance. This certificate is sent approximately 1 hour following the conclusion of the event and is sent via an Adobe Connect thank you email. Please keep an eye on your email for your certificate. Finally, this event will be archived in approximately 3 weeks on OJJDP's online university at www.ojjdpou.org, where you can also find additional resources and view past webinars. Again, thank you for joining us today. I will now turn it over to Katie Penkoff from the Raise the Age Training and Technical Assistance Center to begin today's webinar.
Thank you so much, Allison. And welcome to all of you, and thank you for joining us this afternoon. My name is Katie Penkoff, and I'm the Project Director for the Age of Criminal Responsibility Research Training and Technical Assistance Center. I will serve as the moderator for today's webinar. We are fortunate to collaborate with the National PREA Resource Center and the Dallas County Sheriff's Department for today's webinar. I would like to briefly introduce our presenters and thank them for sharing their time and expertise. Joining us today are Michaela Bowman, Co-Director of the National PREA Resource Center at Impact Justice, and Sergeant Ruthie McCain, PREA Coordinator with the Dallas County Sheriff's Department. You will find more information about each of our speakers in the brief bios contained in the handout pod. We have 3 learning objectives today. First, you will learn about the standards of the Prison Rape Elimination Act as they relate to youth under the age of 18 under adult court supervision and incarcerated or detained in a prison or jail. Secondly, you will learn about the precautions public safety professionals must take and the challenges they face when housing and seeking to protect youth and their care. And finally, you will learn how these challenges relate to age of criminal responsibility policies. The overarching goal of the Age of Criminal Responsibility Research, Training, and Technical Assistance Center is to provide states with an age of criminal responsibility set under 18 and those who have recently passed legislation to raise the age with the research and data needed to make informed decisions about their justice policies and implementation strategies. In line with this goal, we have developed this webinar series utilizing experts from the field who are impacted by age of criminal responsibility policies. In our second webinar in the series, we were fortunate to collaborate with the Justice Policy Institute, the Campaign for Youth Justice, and the TOE Youth Justice Institute at the University of New Haven, where we engaged in a careful examination of the Justice Policy Institute's Raise the Age, Shifting to a Safer and More Effective Juvenile Justice System report. That is also one of the handouts that's in your handout pod. Our webinar today focuses on the practical impacts of age of criminal responsibility policies from the perspective of public safety professionals. As we learned in the second webinar, states that have raised the age or are considering such legislation have taken steps to move towards a more developmentally appropriate approach by using the following 7 strategies that were referenced in the Justice Policy Institute's report. The first was expanding the use of diversion, The second, they made probation and aftercare approaches more effective by using evidence-based practices. They addressed young people's mental health needs outside of the deep end of the system. They reduced the use of pre-trial detention. They reduced the reliance on facilities and focused resources on community-based approaches. They kept young people safe by complying with the Prison Rape Elimination Act, and they improved their juvenile justice system's management of resources and strengthened strategies to serve young people more effectively. These same strategies that jurisdictions have used to be more in line with the developmental approach to juvenile justice reform have also increased their capacity within the juvenile justice systems to absorb older youth in states who have raised the age of criminal responsibility. During this webinar, we will be discussing Strategy 6, complying with the Prison Rape Elimination Act, in more detail. As we will learn today, law enforcement officials across the country experience financial and logistical challenges in complying with this mandate. As stated in the Justice Policy Institute's report, in Texas, law enforcement officials who oversee county jails have raised concerns about the costs of complying with PREA and have supported raising the age for 17-year-olds because it will help them address PREA mandates, avoid costs, and keep youth safe. The sheriffs of Brazos, Dallas, and Harris counties said they prefer to see these teenagers move to facilities with rehabilitative services better suited for their age. In addition to providing rehabilitative and safety service to 17-year-olds, raising the age of juvenile jurisdiction would provide long-term cost savings to counties struggling to comply with the Federal Prison Rape Elimination Act. We will hear more about the challenges law enforcement officials face from Sergeant McCain later in today's presentation. An important first step in understanding the challenges law enforcement officials face in complying with PREA is developing an understanding of the Act, the Prison Rape Elimination Act, the high-risk populations that have been identified through research, and the specific standards related to youthful inmates and youthful detainees. I will now turn it over to Michaela Bowman, co-director of the National PREA Resource Center, who will address these topics.
Thanks so much, Katie. It's really nice to join you all today. I'm going to be talking about the standard, the youthful inmate standard that's relevant to this conversation. But before I do that, I just want to start with a little bit of a background about the law and the standards. This may be familiar to many or most of you, but just to make sure that everybody understands what we're talking about when we talk about the PREA standards and the law itself and the difference between the law and the standards and how these impact state and local jurisdictions. So a tiny bit of history. PREA, the law, the Prison Rape Elimination Act, was passed unanimously by both the House and Senate and signed into law by President George W. Bush in 2003. That law accomplished a number of things. One of the things that it did is that it mandated the Department of Justice to take on a really significant research project looking into the incidence of sexual abuse and sexual harassment in confinement, the causes and consequences of that abuse and harassment nationally. So it mandated that that research take place, and it also provided funding for that research. Another thing that the law accomplished was that it created a commission, and it required that commission to draft a set of standards. That was the National Prison Rape Elimination Commission. It was a bipartisan commission, and their charge was the drafting of a set of standards designed to prevent, detect, and respond to sexual abuse and sexual harassment in all forms of confinement. Those include prisons, jails, juvenile facilities, community confinement facilities, and lockups. And then the law mandated that once the National Prison Rape Elimination Commission had drafted those standards, they would turn them over to the Department of Justice, and the Department of Justice would review them and pass them as a federal regulation. So the commission did that. They spent years studying the causes and consequences of sexual abuse and confinement. They drew on the expertise of hundreds of people throughout the criminal justice system and academics to look at prevention methods, to look at operational issues, to look at data, to look at what is known about who is most vulnerable to sexual abuse and confinement, to look at response strategies, to look at investigative issues, and then sort of back-end criminal justice issues around prosecution of sexual abuse and confinement. So they spent years, and the standards that they drafted were the result of not only their own years of study and drafting, but then the result of public comment that they received back from all over the country. And that draft was sent to the Department of Justice. The Department of Justice similarly spent more than a couple of years studying the issue, going back to those experts, and really refining a set of standards that could be applied in all confinement all confinement settings around the country. They passed those standards in 2012, and they went into effect in August of 2012. And those standards are essentially a federal regulation, what's called a final rule. One of the things that I think it's really important to understand is that the research identified really high-risk populations, subpopulations, among the larger population of confined adults and juveniles. One of those populations, the population we're talking about today, are youthful inmates in adult facilities. Also, among the high-risk populations are mentally ill inmates and lesbian, gay, bisexual, transgender, and gender nonconforming inmates. And within this group, transgender and gender nonconforming inmates are at exceptionally higher risk for being sexually abused. But one of the points that I think is important to make is that when you look at the rates of sexual victimization in confinement, those rates are really driven by these significantly more vulnerable populations because they are an average. And once you start looking at these higher rates, you see pretty dramatic differences between the vulnerable populations and the general population in confinement. So the standards took these vulnerabilities into account and created very specific protections for those populations that were at high risk. So today we're going to talk about the Youthful Inmate Standard that was designed to address the very particular vulnerability of youthful inmates in an adult facility. Now, you see the title of this slide here says Youthful Inmates and Juveniles and Youthful Detainees. We're going to talk about juveniles and youthful detainees in a moment, but we are specifically first talking about youthful inmates in adult facilities, that is prisons, adult prisons and jails, and community confinement facilities. So the standard prohibits the placement of youthful inmates in a housing unit where they have sight or sound contact with adults. That sight or sound contact is literal, so that means not just that they shouldn't be allowed to stand next to and have a conversation with an adult inmate, but if they can hear an adult inmate yelling down the hall to them, or see out in the yard an adult inmate gesturing to them, then the standard has not been accomplished. The purpose of the standard here is to protect youth in an adult facility from being sexually harassed through verbal comments, lewd gestures, other kinds of harassing noises or visuals. So youthful inmates have to be in a housing unit where they are completely sight and sound separated from adults. This standard also requires that the agency make its best efforts not to put youthful inmates in isolation to maintain sight and sound separation. The term isolation is used in the standards generally to refer to what most people think of as protective custody, sometimes administrative segregation, disciplinary segregation, but generally here we would be talking about protective custody where someone would be locked down 23 hours a day. So the best efforts piece of this is taken very seriously by both the Department of Justice and the auditors. That means that that not simply that some effort is made, but that all of the alternatives to placing a youthful inmate in protective custody in some form of isolation in order to accomplish the sight and sound separation have been explored, and they truly are not possible. And we'll talk about that a little bit more in a moment. The standard also requires that absent any exigent circumstances, the agency cannot deny daily large muscle exercise or legally required special education to meet this standard. Daily large muscle exercise, when we talk about large muscles, we're generally talking about the thighs, right? So we're talking about running. Large muscle exercise can't really be accomplished in a cell. It requires being able to be outside or possibly on a treadmill, but it really does require the ability to run. So the standard goes on and requires that youthful inmates have access to programs and work opportunities to the extent possible, and also to all legally required special education that's necessary to provide to them that's age appropriate. The standard also says that outside of housing units, either that same sight and sound separation must be maintained or those youthful inmates in an adult facility must be under constant direct staff supervision. And direct staff supervision is a generally accepted term, but what the Department of Justice means specifically when they use that term is that they must be within sight and sound distance to the inmate. That is, that they can hear what the inmates are saying at all times. So that is direct staff supervision. There are a couple of different ways that standard can be met outside of the housing unit. Finally, I think it's really important to understand that the youthful inmate in an adult prison or jail is someone who's under the age of 18. That's regardless of the person's legal status under state law. So if someone is an adult at the age of 16 or 17 in your state, that does not change the fact that they are a youthful inmate for the purposes of meeting this standard. There's a lot of confusion about that, we find, not just with respect to the standard, but all the standards where there's a state law that in some ways slightly contradicts the standards. The assumption is that the state law, sometimes is that the state law takes precedence, but in order to comply with the PREA standards, the state law is essentially irrelevant here. There are a couple places in the standards that make exceptions where there is state law that contradicts, but this is not one of them. So if for instance, a state defines a youthful inmate as anyone under the age of 21 and has a practice, or a state agency, any jurisdiction, defines a youthful inmate as anyone under the age of 21, and they keep those inmates separate from anybody over the age of 21, it would still be the case that in order to comply with this standard, anybody who's 17 or younger would have to be kept separate from anyone who's 18 or older. So we see in states where the age of majority is 16 or 17, but they have a practice of keeping people who are 18 or younger separate from anybody 19 or older. In those states, they still have to keep the 17 and 16-year-olds separate from 18-year-olds in order to meet the standard. So in order to meet the standard, sight and sound separation in the housing area and sight and sound separation or direct staff supervision outside of the housing area for anybody under the age of 18 from anybody 18 or older, regardless of what state law, regardless of whether they, and of course there are youth in adult prisons in some instances because state law treats everyone at the age of 16 or 17 as an adult, and in other cases they may have simply been prosecuted as adults because of the nature of their crime. So finally, separation from those who are 18 or older is mandated even if the states charge them as adults, and they must be separated from everyone over the age of 18, even if those 18 or older are treated as youthful inmates by the state, just restated there. So I just want to point out the lockup standard for a moment. In lockups, the standard similarly applies to anyone under the age of 18, whether they're being held as a juvenile or an adult. The standard does not apply to juvenile facilities or community confinement facilities. I misspoke at the beginning when I said community confinement facilities. This standard does not apply in juvenile facilities, and it does not apply in community confinement facilities. The standard in a lockup is simply that juveniles or youthful detainees, anyone under the age of 18, regardless of whether they're being held there as a juvenile delinquent or because they have been arrested as an adult under the age of 18, must be kept in a separate cell. The sight and sound separation requirement is not the same, but they do need to be held in a separate cell. So just a few words about what auditors look for when they assess compliance with the standard. I mentioned this before. One of the things that they are going to look at is whether the agency has really examined all the options for housing youthful inmates in a manner that ensures that sight and sound separation from older 18 or older inmates. That means that they have an understanding of what those options look like, right? And we at the Resource Center do a fair amount of training of our auditors on what kinds of arrangements can be made in order to meet the standard, and we're certainly available to provide that assistance to agencies that reach out to us. As a general matter, I think it's important to understand that an auditor is going to ask whether that agency has looked at moving youthful inmates to another facility and working with jurisdictions in a particular region to pool their resources if the ability to create a separate unit isn't possible at their facility. They're going to be looking at the use of sight and sound barriers inside housing units to ensure that that true sight and sound separation is maintained. And the other thing that I want to point out is that the use of isolation is not only not acceptable if there's no possible alternative, but it might not actually satisfy the standard if it doesn't ensure true sound separation. Many of us have been in PC units and other SEG units where there's a great deal of yelling from cell to cell and communication, at least verbal communication. If youthful inmates are in a SEG unit and can hear other inmates yelling to them, then that sound separation has not actually been accomplished. So the standard says that best efforts need to be made to avoid the use of isolation, but that does not mean that the use of isolation necessarily meets the standard. It would depend on the configuration of that unit and just how separate the cell is where the youth is kept. Finally, just a note that it's possible that youthful inmates can be housed in juvenile facilities to remove them from adult facilities if the adult facilities cannot otherwise meet standards. This could be very difficult to achieve in any given jurisdiction. Right? It requires a coordination between the courts and the different correction systems, the juvenile system and the adult system. But as far as federal law goes, it is possible, and as far as meeting the standard goes, it is one option for meeting the standard. And as I said at the beginning, this particular standard does not apply in juvenile settings. There are obviously other federal laws that impact the housing of adults in a juvenile facility that may impact the decision of whether to do that or not. But that is as far as PREA is concerned, one possible way to meet the standard. With that, I would just say that you should feel free to contact the PREA Resource Center. We respond to field-initiated requests for technical assistance and are very happy to talk to you if you have questions of us beyond the course of this webinar. And with that, I will turn it back to Katie. Thank you very much.
Thank you, Michaela. We appreciate your time and expertise. And now that we've learned more about the Act, high-risk populations identified through research, and the standards for protecting youthful inmates, juveniles, and youthful detainees, we will now turn the presentation over to Sergeant Ruthie McCain, PREA Coordinator for the Dallas County Sheriff's Department. Sergeant McCain will share more about how Dallas County implements PREA and the challenges they face in doing so. So, Sergeant McCain?
Thank you, Katie. Let's see, where do we start? As Michaela stated earlier, the Congress unanimously passed the Prison Rape Elimination Act of 2003, which we know as PREA, in response to concerns about dangerous conditions within the prisons. And according to PREA Standard 115.14, the Act restricts placement of anyone under the age of 18 in the adult jails and prisons. It bans the housing of children in the adult general population, prohibits contact between children and adults in the common areas. It also requires children to be constantly supervised by staff. When we say constantly supervised, we have what we do is direct supervision. And we have a facility that's just for direct supervision, but we don't allow our 17-year-olds in that facility. PREA also recognizes that 17-year-olds are more acceptable to sexual assault, violence, and abuse due to their age, their size, maturity, and life experiences. As the PREA coordinator of Dallas County, we're committed to complying with the PREA standards. We support any regulations designed to keep the inmates in custody safe, and as a result of trying to comply with keeping the youth safe, it has really brought on financial and operational burdens to the county. Our youthful male population that we house here are located on the 6th floor of what we call our West Tower jail, and we house our female population on the 8th floor of the West Tower as well. On this slide that you see, some of the issues that we face are the space issues, classification issues, and of course the cost. The medical department has an increased expense as well, and there are limited resources. On the average Dallas County Sheriff's Department, we average about 58 youthful inmates daily. There was a time when we were housing at least 72, but our population has gone down. And currently there are 9 different mandated classifications for our male youthful population and 4 for our female youthful population. Therefore, this presents the challenges of space issues. The youth, they only occupy a fraction of the beds in our housing units. And because of the different classifications, some of the tanks or the pods may only house up to 2 inmates. You may only have 2 assigned to that particular tank. So as we're implementing PREA, it renders the remaining beds unusable. Therefore, we have an abundance of improper use of space. An example of the different classifications that force us to separate these youths may include the criminal history that they have, whatever felony or misdemeanor charges they may have, and the interviews that we do prior to them being booked in, if the inmate has potential to become a victim, physical or sexual abuse, if the inmate is a potential abuser of the tank or a leader in that tank, and we also have to consider the psychological and medical needs. As far as the cost is concerned, these requirements have greatly affected our county jails, also forcing us to expand extraordinary efforts and the cost to comply. For example, at one point when the population was a lot higher, we were forced to open another facility to accommodate the 17-year-olds, which increased our cost tremendously. On the average, it would cost an additional $80,000 per week to house these 17-year-olds. That's over $4 million a year. And our medical department was also impacted. It was estimated that the expected additional annual medical costs would be $238,000. The medical costs, which it included an additional hiring of staff, training, the equipment, support, and the IT support of the youth section. But now our population is down. That cost has decreased a little, but it's still a burden. The juvenile detention facilities are designed to offer developmentally appropriate services and programs to the youth. The facility must be sufficient operational and structural capacity to effectively manage programming for a full range of developmental and safety needs of all residents in the facility's care. Our facilities are really not equipped for all of that. And it can, like I said, it can be very costly and difficult to retrofit them. The juvenile detention facilities are also able to take the time necessary to mentor, counsel, and discipline the youth inmates in order to help them obtain the necessary social skills or education to prevent habitual behavior. While the adult facility, on the other hand, we're not equipped to do those type of things. The 17-year-olds are at a higher risk of suicide when they are housed in the adult facility. Although we are a mega jail and able to do a lot more, our department is still limited on the types of resources we can offer our 17-year-olds. We cannot give them the extra time necessary to offer comfort and support that they may need in order to survive incarceration in an adult facility. It's not safe for 17-year-olds to be in the same area as the adults. For example, some of the challenges we've had with recreation, time and making sure that the adults have completed their recreation, and we also still have to allot time for the 17-year-olds to do recreation as well. The medical area, sending them to the nurse's station. You have to coordinate and make sure that they're not in the same area at the same time. The inmate programs that we have offered, such as law library, the GED courses, and job training, some of those are limited, and the church services as well, because our volunteers are limited, and they are on a schedule where they only come so many hours a week. And so because we have to allot for our adult population, a lot of times the 17-year-olds will miss out on those opportunities. And in order to, the next slide here, in order to keep youth separate and safe, the Dallas County Sheriff's Department, we provide separate resources, separate training, and separate programs. Although we offer these things, a lot of time it's limited because of our volunteers and then the staffing as well. So in order to keep the 17-year-olds separate and safe from the adult population, our department, we have to provide those separate resources, training, and programs. This creates a hardship on the volunteers or the teachers who have to provide separate services. The volunteers may not have the necessary training to effectively mentor or teach a child. So in a sense, it's almost like we have a jail within a jail. So it's kind of, it's hard to separate. It's just the cost. If we had the funds to do it, we could probably keep that other facility available and just run a separate facility, but unfortunately we don't have those funds. So to sum it up, simply put, Texas County jails cannot continue to house 17-year-olds with adult inmates or in isolation cells without financial costs or liability risk. With that being said, I will turn it back over to Katie.
Thank you so much, Sergeant McCain. We also greatly appreciate your time and expertise and in sharing your experiences implementing PREA and the challenges your department faces in housing and serving 17-year-olds. So also, as cited in the Justice Policy Institute's report, they received this information from Massachusetts Department of Youth Services in their annual report. And here, as it says, raising the age of juvenile jurisdiction furthered the Commonwealth's efforts to comply with the federal Prison Rape Elimination Act. This law requires courts and facilities to provide sight and sound separation between adults and juveniles in order to protect young people under the age of 18 from possible rape and sexual assault in adult holding cells and prisons. Costly construction and staffing changes in the adult facilities were not needed in Massachusetts because of the shift of youth under 18 to the juvenile system. So just another quotation here from a state who has raised the age of juvenile jurisdiction or age of criminal responsibility, and as a result have come into compliance more so with PREA. So at this point, we would like to open it up for presenter Q&A. So Ms. Bowman and Sergeant McCain are available to answer questions that folks may have related to the Youthful Inmate Standard, as well as implementing PREA for juveniles being served in adult settings. So it does look like we have one question thus far, and it relates to whether anyone has data on the number of youthful inmates who are placed in protective custody. Michaela, can you speak to that question?
I wish I could. I don't know. I do not have numbers. I suspect that the use of protective custody for youthful inmates is not at all uncommon, but I'm not aware of any research that, at least national research, that counts the number of youthful inmates in PC.
Okay. Well, thank you, and we can do certainly some follow-up here. So any question that requires us to engage in some additional research, we receive a registration list with email addresses of those who have participated in today's webinar, so we can certainly follow up with answers to questions that are asked during the webinar. We have another comment from someone who says the one issue that was not discussed for the under 18 population is the educational requirements that are mandated by federal law. Michaela, can you speak to that?
Sure. Yeah, it wasn't in my slide, but I mentioned it. It is in the standard. The standard requires that youthful inmates not be denied any legally required special education services to comply, in order to comply with this provision. In other words, any federally and locally mandated special education services that someone under the age of 18 would legally need to receive must be received, and the need to keep them separate from anyone over the age of 18 in the facility or under constant direct supervision outside of their housing unit can't interfere with the provision of that legally mandated special education. So, I mean, it raises a lot of the kind of logistical and financial challenges that Sergeant McCain raised, right? Because if you have a classroom and you have youth who are under the age of 18 in a classroom with someone who's 18 or older, they have to be under constant direct supervision by security staff in order for that to be acceptable.
Thank you very much, Michaela. And Ruthie, can you speak to the provision of special education services within the Dallas County Jails?
Yes, within Dallas County Jail, a lot of the problems that we have with our facility is the volunteers are getting the teachers. And then I don't know what the policy is or where it states, but some of the courses, the 17-year-olds still have to have parental permission to participate. And with that being one of the requirements, because some of the 17-year-olds are disconnected with their parents or guardians, that could cause a problem. So they won't have access to those courses because they don't have that permission to take the courses. And like I was saying, it's just limited resources as far as the volunteers coming in. We have them coming in to teach the adults, and the schedules, or they don't have enough volunteers to come in as well to teach the youth because we don't have as many youth as we do adults.
Right. Thank you so much, Ruthie. I appreciate that. Our next question is, what other aspects should be considered to comply with standards when trying to raise the age higher, say to 21 or 25? Michaela?
Sure. So, I think one of the things that we say over and over again, but the impact of it, or so the meaning of it, gets lost, is that this separation requirement does not apply in juvenile facilities under PREA. So as far as PREA is concerned, if you've raised the age of majority to 20 and anyone under that age is being placed through the juvenile justice system and ending up in a juvenile facility, there's no concern as far as compliance with PREA goes. As long as 17 and younger, people who are 17 and younger are kept separate from people who are 18 or older in an adult facility, then PREA is satisfied. So it's important to understand that the real challenge here is for states where the age of majority is under the age of 18. Raising it higher doesn't in any way challenge compliance with PREA.
Okay, thank you. So our next question is, it asks, in what ways are states addressing the needs of LGBTQ youth or individuals without segregating or using solitary confinement? Michaela, maybe you can speak from the National PREA Resource Center and what you see, and then maybe Sergeant McCain, you can speak on what you see in your facilities or what you do in your facilities.
Sure. So one of the things that we really stress is that segregation should be an absolute last resort. People who are vulnerable, whether it's because they're youthful inmates in an adult facility or because they're LGBTQI, should not be punished, essentially, for that vulnerability. The standards create a requirement that people are screened for those potential vulnerabilities. That is, their age matters, right? But they also need to be asked about their sexual orientation and gender identity. They don't have to answer those questions. They need to affirmatively be asked. And facility screeners need to also do a subjective assessment for whether they might be perceived to be LGBTI, basically based on whether they're gender conforming or gender non-conforming. So the standards require this objective, the use of an objective screening instrument with trained screeners who are able to identify people who are vulnerable. And when somebody is identified as vulnerable, which may be because of their sexual orientation or gender identity, then that information needs to be used in making housing placements. So the obviously traditional way of keeping people safe is to put them into PC, but we really are helping agencies to find alternatives to PC, to find housing units where people are going to be safe in general population. Keeping essentially more vulnerable inmates separate from people who are more likely to be abusive in general population, making sure that people who are more vulnerable are in areas of the facility that receive higher levels of supervision. If possible, placing somebody who is more vulnerable in a housing unit closer to the officer's desk at the front of the pod, right? We're talking about obviously particular design, but in different kinds of facilities with different designs, there are different ways of addressing these challenges. But one of the things that we really encourage agencies to look at is that just because somebody is identified as potentially vulnerable doesn't mean that the only safe place for them in the facility is protective custody. And I think one of the things that I would really encourage people to think about is that the standards as a whole and the work that people who are committed to creating sexually safe environments in confinement are doing is designed to make the entire environment safer for everybody, right? Obviously, there are still going to be people who are at much higher risk, but the standards don't work if they aren't working as a whole, right? So we're creating environments where people feel safe to report, where there really are actual safe avenues for reporting, where investigations are consistent and thorough and objective and prompt, where a response to an allegation is appropriate and victim-centered, and where there are real consequences as the result of an investigation. When those things are happening, an environment is going to be safer, and it's going to be much easier to keep even those people who are more vulnerable in the facility safer in the general population. So, it's a very difficult question to answer because obviously it isn't always possible to create those ideally safe environments, and there are some people who are extremely vulnerable in their institutions, and some institutions face a lot of constraints in terms of where they can house people, particularly in jail settings where there's a lot of turnover and not a lot of extra space to work with. But creating housing units where vulnerable people are generally kept together and away from people who are going to be more likely to be abusive is one of many strategies I think that we see agencies using to keep LGBTQ people safe in general population. And I just caveat that by saying that the standards do prohibit the creation of a separate unit or wing that is solely for LGBTI inmates or residents. They can be a general special housing unit or special needs unit, but not a unit designated specifically for LGBTI people.
Thank you so much. And Sergeant McCain, do you have anything to add about how the Dallas County Sheriff's Department?
Yes, I do. At the Sheriff Department, what we do is once they are booked in, they do ask them the type gender questions. There's a form that they fill out, and it kind of gives you an idea whether or not they are identified as vulnerable. But initially they will be placed into a general population unless they request. We have a general special housing unit that they can fill out a form and go into the special housing unit. But once say for instance they get in that special housing unit and are in general population and they still don't feel safe, we won't move them unless they send out a request saying, I don't feel safe in here. And then at that point, we use all our resources, and they may end up in isolation as a final resort. But initially, we do send them to general population. They have an option to go to the special housing unit, and then from there, we have protective custody.
Okay, thank you so much, Sergeant McCain. Our next question is, what is the position of youthful offenders still under juvenile court jurisdiction over the age of 18 being in youthful facilities with other youthful offenders under the age of 18? Michaela?
So that's a difficult question to answer without knowing a little more information because the term youthful facility isn't isn't a defined term under the standard. So if the facility that you're talking about is an adult facility under the standards, then the standard applies regardless of whether the youth is being prosecuted by is under juvenile court jurisdiction or not. If the facility that you're talking about is an actual juvenile facility, then under the standard, then the standard does not apply. So then we get to the definition of a juvenile facility versus an adult facility. And you can read the standards, the definitions are there, but I will just say briefly that a juvenile facility is defined, first of all, a juvenile is defined as any person under the age of 18 unless under adult court supervision and confined or detained in a prison or jail. So if this person is under 18 and under juvenile court jurisdiction, then perhaps they are still a juvenile. A juvenile facility is a facility primarily used for the confinement of juveniles pursuant to the juvenile justice system or criminal justice system. So a juvenile facility, when they've further defined primarily used for to mean that's one more than half, meaning like if there were 100 juveniles in the facility, 100 people in the facility, and 51 of them are under juvenile jurisdiction, then that would be a juvenile facility. If, say 20 of them were under juvenile court jurisdiction and 80 of them were under adult criminal justice jurisdiction, then that would be an adult facility. If 20 of them are juveniles under the juvenile justice system and 80 of them are kids who are there pursuant to for some other reason, for treatment, but they haven't been mandated to be there by the juvenile justice system, then that may not be a covered facility, period, under the standards. So if the facility is primarily used for the confinement of juveniles pursuant to the juvenile justice system, then it is a juvenile facility, and in that case, this standard doesn't apply. But as soon as it's defined as an adult prison or jail or not community confinement facility, adult prison or jail under the standards, then the standard applies regardless of the jurisdiction of an individual youth in that facility. So I don't know if that totally answers the question because I'm not entirely sure what's meant by a youthful facility in this case. And I realize that every state has different definitions and terms that they use to apply to youth and adults of different ages and in different states of the criminal and juvenile justice systems. But for the purposes of PREA, I would look at the PREA definitions, and those are the definitions that apply when determining whether this standard applies.
Thank you so much, Michaela. We have a question here. It says the presentation spoke to PREA relative to locked facilities. Are there PREA regulations or requirements that speak to similar expectations in unlocked facilities? And they go on to give an example, for instance, residential treatment centers that provide care to youth ages 13 to 19.
So that goes specifically to what I just said. So the standard does not apply in juvenile facilities, period, right? The Youthful Inmate Standard. PREA applies to juvenile facilities, and that includes both secure and non-secure juvenile facilities. However, a juvenile facility is defined as a facility that's primarily used for the confinement of juveniles pursuant to the juvenile justice system or criminal justice system. So if, let's say, it's a residential treatment center and I can send my 14-year-old child there as a mother because I'm concerned that she has a drug addiction problem, but she's not been in any trouble and she's not been in the juvenile justice system. There's no consequences for her. There's no juvenile justice consequences for her walking away. Then she is not there pursuant to the juvenile justice system. In a facility, the determination is made by the facility, and they will look at whether they are primarily used for and primarily defined as more than half. So again, 51 out of 100, and obviously those numbers numbers vary depending on what the total is, but more than half of the people in that facility, the kids in that facility, are there pursuant to some kind of juvenile justice or criminal justice system mandate, and there would be some kind of juvenile justice or consequences if they were to walk away. So it may not be locked, but it could qualify as a juvenile facility under PREA if most of the kids there, or more than half of the kids there, are there with some kind of juvenile justice mandate. Again, though, the Youthful Inmate Standard will not apply. It simply means that those facilities are juvenile facilities under the PREA standards.
Okay. Thank you so much. We have another question here that asks about special ed requirements that are provided by licensed service providers or licensed educators here. It says, can you speak to those educational requirements? One resource I want to put that I'm currently putting in the chat box for everyone to see is the National Technical Assistance Center for the Education of Neglected or Delinquent Children and Youth. So this was certainly a training and technical assistance provider that speaks directly to special education services provided for young people up, of course, through the age of 21 who are in facilities. So, Michaela, is there anything that you would add to that?
No, that's great. I'm not an expert in that field.
Okay. And then the next question focuses on policies that restrict youth from online studies. Are there any specifically that either of you know about, or is that really more of a facility by facility or system by system policy that would restrict that?
I mean, I think in general, anybody studying youth are faced with, youth are generally a protected population for any kind of research, and so there's, IRBs, human subject review boards that review any kind of research that is going to involve youth, and particularly youth who are confined are very strictly protected population. So anybody who wants to conduct research that involves youth, and particularly youth who are confined, is going to have to demonstrate to a human subjects review board, either the agencies or their academic institutions, review board, that the study is ethically sound, and that's really challenging to do. So there are, all kinds of policies that restrict research on youth, but that's sort of outside the scope. I'm not sure specifically what that question is referring to.
I'm thinking it might be online educational studies, and it looks like we might be out of time and need to turn it back over to INTAC. But what I can tell you is in the slide presentation, we have information about our online community of practice and a way for you to request access to our online community of practice where this conversation can continue and where we can address additional questions. So I just wanted to thank Ms. Michaela Bowman and Ms. Sergeant Ruthie McCain for their time and expertise. And Allison and Adam, I will now turn it back over to you.
Thank you, Katie, and thank you to our presenters for a great discussion on this topic. We have just a few brief reminders. This webinar will be archived on OJJDP's online university in approximately 3 weeks. For more information, please contact the Age of Criminal Responsibility Research, Training, and Technical Assistance Center, and you may also contact OJJDP or INTAC via our help desk by following the contact information on the slide. Also, please take a moment to complete the online feedback form. And thank you again for joining us today. Have a great afternoon.